Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about parenting and employment. Cases that should have gone to the Supreme Court of Canada, but didn't. Brian Sewan had a job with an environmental company in Burnaby. He was a new parent when the company suddenly lost an employee, and they asked him to take over for that position. He was supposed to go out of town for 8 to 10 weeks at a time, and wouldn't be given any money from the company to return back home to see his new child and to take care of his parenting responsibilities. As a result, Mr. Sewan turned down the opportunity at the employer. The employer gave him an opportunity to reconsider and threatened that if he didn't reconsider his position, he would be terminated from the employment. Unfortunately, Mr. Sewan didn't reconsider, and his employment was terminated. The case went to the Supreme Court of Canada on the question of whether or not this constitutes discrimination in employment on the basis of family status. If a person has a young child, they have certain parenting responsibilities at home that they need to take care of. Telling them that they can't continue their employment with the company because they're not willing to change their position to engage in a different job that would take them away from those parenting responsibilities, arguably, according to Mr. Sewan, constituted discrimination on the basis of employment status. Unfortunately, the Court of Appeal disagreed, and the Supreme Court of Canada refused Mr. Sewan's application to hear the case, which leaves a really important, unanswered, and frustrating question. Can employers just unilaterally decide to change the terms of a person's contract of employment to prevent them from engaging in their family activities? And does any role play in this that Mr. Sewan was a man and not a woman? Women often have been successful in lawsuits on the basis of discrimination, on the basis of family status, where they've been terminated for becoming pregnant or for having a child. Why is it any different because Mr. Sewan is a man? And why can the employer unilaterally decide to change the terms of his employment contract after he's already had a child in a way that would take him away from his parental responsibilities? This case could have a chilling effect on the ability of fathers to play a significant role in the parenting of their children because it prevents them from taking opportunities at their employment and continuing their employment while also managing their responsibilities at home. The Supreme Court of Canada should have taken this opportunity to better clarify the importance of having a relationship with a father who wants to be involved with the child and also allowing that father to continue his employment. And this was a real missed opportunity for the court and a case that unfortunately should have gone to the Supreme Court of Canada but didn't. You're watching Cases That Should Have Gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and tune in next week for another exciting episode of Cases That Should Have Gone to the Supreme Court of Canada but didn't.